Well, let's start at the Supreme Court. Now, Chief Justice Sophia Akufu has chided two NDC MPs of Parliament for members of Parliament, I beg your pardon, for adding the title Honourable to their names in a writ that was before the court. She described as improper the practice where members of Parliament add such titles to their names. Now, the Member of Parliament for Ashaiman constituency, Ernest Nogbe, and the Member of Parliament for the Draboso constituency, Kwabena Minta Akando, were before the Apex Court today seeking a revocation of the appointment of Otiko Afisa-Jaba as the Minister for Gender, Children and Social Protection due to her failure to undertake the mandatory national service. We've been speaking actually to members of Parliament on what they think about the dishonourable statement by the Supreme Court. So let's go over to Parliament now, where the Vice Chairman of Parliament's Legal Affairs Committee, Alexander Kojo-Aban, has criticised the decision by the Supreme Court to throw out actually that case against Gender Minister Otiko Afisa-Jaba on technical grounds. Now, the court threw out the case because the license of the plaintiff's lawyer had expired. But the lawyer Aban says this deprives the plaintiffs the opportunity to get justice. He, however, agrees with the Chief Justice's criticism of the plaintiffs for using Honourable as title preceding their names. Joseph Opoku-Gakpo is standing by in Parliament. He's been speaking to the parliamentarians. Let's get to hear from him. Hello, Joseph.
Hello, Gifty.
It's quite a lot of things happening. First, there's Otiko issue, and then on the other hand, there is the this honourable mantra. I don't know how you want to start it, but we can start with the Otiko case, and then we can get to the reaction that has come about the use of honourable as a title, Joseph.
So, in relation to the Otiko case, well, you would know that that issue became very topical here in Parliament at a point in time. MPs had to vote on as to whether they would allow for her to be approved as a minister. Eventually, we saw a situation of the majority having their way and she being approved. And so for MPs, both on the majority and the minority side, well, they had really been looking forward to this particular case and what the outcome would be. I've been having a conversation with lawyer Aban, who is the vice chairman of the Constitutional Legal Affairs Committee. Well, he thinks that the case should not have been thrown out on the technical ground, and he felt the case should have been heard because the client shouldn't have been penalized for a fault of the lawyer. But he thinks that the Supreme Court pronouncement when it comes to the use of honourable is rightly in place, and that MPs should desist from using that particular title outside Parliament. I've been speaking to him.
From Alexander Kojo-Aban, but just so you know, we're talking about what happened at the Supreme Court today. We can hear Mr. Aban now.
And she was really on that you know, it is dishonorable for them to hold themselves out as honorable in terms of the names that they put on their documents and all of that. What do you make of that?
Thank you very much. I think that this title of honorable, we are flogging it too much, right? I think that it is just a title that should be used inside of Parliament, right? You bear your name, you have your official name. Honourable is not part of your official name, right? So you just, I mean, for courtesy's sake, just like I will meet a lawyer and I will say that my learned friend, right? But it doesn't become part of your name as my learned friend. It's just for purposes of courtesy in the chamber. So if you are addressed as honourable, does not mean that you should make it part of your name. I remember that I was opening an account. A bank was trying to open an account for a couple of members of Parliament. And somewhere insisting, when I went in the checkbook, they had put honourable there. I said, it is not part of my name. And I don't go anywhere, for instance, calling myself honourable. I just call my name, and that's it. So for me, I agree with the Chief Justice. To the bit that he said the court dismissed the matter on that technicality, that the lawyers were not licensed. In fact, the authority in that case is Kobo versus Amusa. It's a case that was decided by the Supreme Court, and I think the lead judgment was given by Justice Enini Yabwa. That case is the authority for the decision that if you are not licensed as a lawyer, then everything that you do as far as your law practice, if you file a writ or you do any of those things, it's null and void. It is still the law, but I beg to differ with the Supreme Court, right? Because no client goes to a lawyer and asks the lawyer whether you are licensed or not. And so I think that if the lawyer knows that he is not licensed or he has some legal impediment, and then he goes ahead to do that, whatever punishment there is must go to the lawyer personally. Because after all, it is just like being a doctor. He has the skill. He is doing it. Just that his enablement to continue is what has been withdrawn a little. So for instance, let us take a situation, because you renew your license yearly. The time has even come for us to renew our licenses for next year. Now, let us assume that 31st of December, your license expires. Between 31st and maybe 15th of January, you have something to do in the court. Would you not do it just because your license has expired? Probably it means that within that period, you cannot do any legal work. I think that any opportunity that the Supreme Court gets, they should revisit that decision because it may...
Isn't that part of efforts to... create substantiality around the institution? People who are approaching the demanding justice must do things right and must have all their records in place, their licensing.
Oh, yes, I know that as lawyers, we must make sure that our license is current and all that. But I think that just like any client would walk to a lawyer to ask him, oh, can you go and defend this case for me? Can you file a writ for me? Can you do this service for me? It is inconceivable for that person to go ahead and ask the lawyer, are you licensed?
In this case, these are members of parliament. Doesn't that even raise the bar that they should have demanded from the lawyer that every document of his was accurate enough before they even allow him to lead them to court?
No, I don't think we should or we should set higher standards for members of parliament as far as this is concerned, because any member of parliament is just a citizen like anybody. And when he's going to see a lawyer to ask him to file a case, he would never even ask the lawyer whether he's licensed or not. I say that is the law now, but the effect of that law may lead to some kind of injustice on a lot of people.
So for you, they should have gone ahead and heard the case and looked at the merits of it and probably
for as long as that is the law. For as long as that is the law, no judge would go ahead, because all the lower courts below the Supreme Court are bound by it. Okay, so it is only the Supreme Court that may depart from its earlier decision, and that's why I'm saying that they may have to later issue a practice note, or when they get the chance, they should depart from this decision, because it will lead to a lot of innocent people being non-suited just because their lawyer was not licensed at the time he filed the suit.
I'm grateful.
Thank you.
I'm taking too much of your time. I know you're going. Well, the hearing has started as well.
Joseph Opoku-Gakpo there speaking to some members of parliament. Two very interesting cases. We're looking at one, the fact that the Supreme Court described as incompetent a rate that is challenging the appointment of Otiku Afisa-Jaba, a Minister for Gender, Children and Social Protection, earlier today. And then the other case, which is the fact that the Supreme Court is describing is describing the use of honourable as the title based on the documents that were presented before them by the members of parliament, describing that act as dishonourable. So we're getting some reactions from parliament. What do they think of it? You just heard Joseph speak to the vice chairman of Parliament's Legal Affairs Committee, Alexander Kojo Aban, who believes that the case shouldn't have been, described as incompetent, or shouldn't have been thrown out, but that it should have been heard. But then he appears to agree with the Supreme Court on the use of honourable as a title. We'll be talking, we'll be going back to Parliament to hear Joseph Opoku Gakpo speak to some more MPs. But Gakpo, members of Parliament in the meantime have also been warning against the impeachment process against Charlotte Osei. They're saying that it could endanger our democracy. What more have they said?
Yes, so I've been having a conversation with some of the minority MPs who think that this is a process that shouldn't have started at all in the first place, and that the president shouldn't have referred even the petition to the Chief Justice to begin looking into this particular issue. Well, Samuel George, who is the MP for Ningo Pram Pram, I've been having a conversation with him, and he thinks that this particular case that is being looked at, to a certain extent, could threaten the very sustainability of Ghana's democracy.
But just so you know, this case comes on the back of yesterday's story that we did about the Supreme Court, or about the Chief Justice putting together a committee to look into the case that's been established against Madam Charlotte Osei, head of the Electoral Commission. So we'll be getting that reaction briefly from Parliament. But as you heard me say previously, minority MPs especially are warning that going through with that impeachment process is an act that could jeopardize Ghana's democracy. Why? That's what we're waiting to hear from the Member of Parliament for Ningo Pram Pram. We're talking about very interesting cases here. One, first of all, we started off at the Supreme Court, where two interesting cases have been heard. Otiku Afisa Jaba had some people contesting her appointment as minister because she did not go through with the mandatory national service. Well, that case has been thrown out because, as we understand, the Supreme Court says the lawyer who represented the two members of parliament, the two NDC members of parliament who brought the case to court, does not have a license. So, and also, we've also heard the Supreme Court describe as dishonourable the use of honourable, or the title honourable, as a prison to the names of members of parliament. Then again, minority members of parliament are warning against an impeachment process that has been started against the chairman of the Electoral Commission, Charlotte Osei. I have Gakpo on the line. It seems we're unable to bring you Sam George speaking on that. But Joseph, bring us up to speed. What are the reasons that they give beyond what you've already told us?
So they make the point that even when you look at how the Electoral Commission has managed the electoral process over the years, Ghana has shown that we are a beacon of democracy in Africa. We've been hailed largely by the international community. We've gained a certain reputation when it comes to how we manage our electoral affairs, and our EC has received a lot of praise over the years from international bodies. That's what the minority MPs are drawing attention to, and making the point that, well, when you look at what we're seeing, it could, to a certain extent, shake the kind of confidence that exists within Ghana's electoral structure generally. And Sam George, then before Ningo Pram Pram, has been drawing attention to what he says was a similar petition that came up against former Chief Justice Georgina Wood at the time that Professor Janef Hazanta Mills was actually the president of Ghana. According to him, there was a prima facie case that was established against the then Chief Justice, but in the interest of the country and to ensure continued confidence when it comes to the judicial arm of government, former President Professor John Mills did not go ahead to refer that petition in question to any committee for them to investigate and begin impeachment process against, so that then he wouldn't have gone ahead to even forward this for the processes of impeachment to begin against Madam Charlotte Osei.
Is this a position that the majority or any of the majority members of parliament agree with?
This is something that, again, I engaged the Vice Chairman of the Constitution and Legal Affairs Committee, Alexander Kojo Aban, on, and he thinks that this was a classical case of the rule of law, which was actually playing out even right from when the impeachment, the petition was filed up until the Chief Justice looked into this and referred this to a special committee. He thinks that per the procedures, we would see a situation where if her hands are clean as far as the allegations against her are concerned, she would come up without being impeached. Well, it's only when the hands are not clean that may result in a situation. And so the MP for Gomua East, the NPP MP, thinks that right procedure is being followed, the right thing is being done, rule of law is being followed. And so, well, the minority virtually has absolutely no business complaining about the procedures that we've seen so far. Kojaban again thinks that in the end, this may end up boosting even more confidence when it comes to the judicial system generally and how people perceive it, because then there would be evidence that when allegations of corruption came up, it wasn't swept under the carpet. It was looked at extensively. They managed to get to the bottom of the matter, and there was a final conclusion on that. He is not of the slightest opinion that this may end up shaking Ghana's electoral system and even affect the level of confidence in the EC in any way.
We're going to, hand over to you to get to speak with the two members of parliament who actually have been in court over the Otiko matter to find out how they feel about how the Supreme Court has handled the matter, even before we talk about the dishonourable, honourable with them. But did any other thing come up on the floor of parliament today, Joseph?
And so today, the processes to approve the budget for the various ministries, departments, and agencies began. There was a report from Parliament's Works and Housing Committee with regards to the budget of the Ministry for Works and Housing. That is being debated for approval. A concern has come up that the budget for that particular ministry for this year has been cut down. The amount that they were given last year has been reduced by something in the region of 9%. Those on the minority side, this is a problem. The Member of Parliament for the Hohoi area, Emmanuel Bejra, drew attention that this is a ministry that does a lot of infrastructure projects. Usually they would need a lot of money to undertake the activities, and so they were expecting that their budget would have been increased. Well, there was also concern right from that particular ministry again that they are in debt to the tune of more than 1 billion Ghana cedis. The unfortunate bit is that their entire budget for this year is only in the region of 190 million cedis.
Okay.
And so there was a concern that there is no way that they would be able to raise enough money to be able to take care of the debt. And so Parliament's Works and Housing Committee is recommending that the Ministry of Finance takes the necessary steps to ensure that the debt that's owed by the ministry is paid. Okay. There's also been a conversation on another ministry, the Ministry of Local Government and Rural Development. Their budget estimates have also come to the floor of Parliament for approval. And a concern came up that with that particular ministry, you would recall that there's been the creation of some new districts. Well, the report indicates that the provisions that were necessary to keep these ministries running were actually not made, which MPs are raising concerns about. And again, well, there's a provision of this particular report that henceforth planting for food and jobs and a number of other social interventions will actually be funded using the District Assembly Common Fund. And some MPs have been raising concerns about that as well.
Joseph, it appears that we can now hear from the Member of Parliament for Ningo Pram Pram on what he makes of the impeachment process that's begun against the chairperson of the Electoral Commission. Well, we can hear him now. And when we're done, Joseph, we'll have to come back to you for you to find out from Members of Parliament, Ernest Nogbe and Mr. Akando, what they make of the Supreme Court decision.
Are beginning to have. This dance will end up in a very, very disastrous place for this country.
And they're just following the rules as have been set down. And the petition got to the president, it got to the Chief Justice, a prima facie case has been determined. And so the processes are ongoing. Are you advocating that we abandon what the rules require that we do?
You know why I said that I laid this solely at the step of the president? I worked with Professor Mills, or we all worked with Professor Mills, and there was a case. That was a petition sent to Professor Mills of blessed memory against the Chief Justice at the time, who the current Chief Justice has succeeded, and Madam Georgina Wood. In fact, there was more than a prima facie case in that instance. She had admitted receiving some of the land, in fact, paid for the land. What did Professor Mills do? He could have as well also proceeded to begin hearings into the Chief Justice. But at that time, don't forget, the NDC appeared to have been losing a lot of cases that were being called by panels that had been empaneled by this Chief Justice. An action to take the Chief Justice out at that time would clearly have been misconstrued to have been an attempt to attack the judiciary by an executive president. President Mills did what was right. The Bible says that everything may seem right, but not everything is expeditious. Okay? And so, yes, it may be right to say that you want to refer this, but is that the best decision you make as president for the Republic of Ghana? So the president should have taken a leave for Professor Mills. When the petition was brought against Madam Georgina Wood, there was more than evidence. She had admitted self-indictment. What did he say? He says, I'm not going to act on it. That is why the Constitution envisages that role the president will play as a gatekeeper for the protection of our democracy. That's why it doesn't say the petition should go straight to the Chief Justice. It says it should go to the president, and he has the prerogative to either forward it or to refuse to forward it. I think the president erred in his decision.
Do you think it's part of the general conversation around this possibly being a witch hunt? We know that the NPP, apparatus has been on Madam Charlotte Osei's neck for quite a while. Could that have influenced the president's decision to have gone ahead to err, in your words, and forwarded the petition to the CJ?
I would not want to go into conjecture or conspiracy, but I believe that the court of public opinion is clear in their minds what the position of the NPP has been on the appointment of Madame Charlotte Osei from day one. I mean, you heard comments by even colleague members of parliament as to how she acquired or got into that office. People forgot her academic credentials and the fact that she was more than qualified for the job of Electoral Commission chair. She oversaw an election that she was supposed to have been appointed to rig for the person who appointed her, and actually declared the election for the other group that had antagonized her from day one. So clearly you realize that there has been a certain subplot. Is that what is playing out now in a grand act? I cannot tell. I have no evidence. I will not engage in that conjecture. But for me, I think that the court of public opinion is there. We're watching, we're seeing, and if it quacks like a duck, it walks like a duck, it has its children lined up behind it like a duck, it certainly is a duck.
My last question would be, where do you envisage this will lead us? She said it's a very slippery area. What exactly do you mean by that? What could the eventual consequence of all of this be, you think?
I've told you that the Electoral Commission is the central pillar of our democratic experience. If you toy with the Electoral Commission and you disintegrate that institution, we will have no democracy to call a democracy. And let us not mistake ourselves to think that Ghana is immune from all the things that are going on around us in the sub-region and in Africa. People are watching. Those who may not remember, not too far ago, just 10 years ago or 9 years ago, 2008, in Ghana, in 2008, when we were waiting for the third round, banks did not open on working days. Those that opened closed at 12. Shops were closed. You could actually feel the tension in the air. You could cut it with a knife. That's how close we came to the precipice in 2008. Ghana is not a special place. Yes, I believe that God comes to rest in Ghana, and that's why we've had our peace this much. But let's not get God angry to take a vacation. Let's not get God angry to take a vacation. Thank you.
Speaking of getting God angry to take a vacation, well, that for the religious people will never happen. But that is Member of Parliament for Ningo Pram Sam George. They're speaking to Joseph Opoku Gakpo. Very soon, Joseph will be talking to Ernest Nogbe and Mr. Akando. They are the two people who took the matter to court, contesting the appointment of Otiku Officer Jaba. Now, the Supreme Court has described that as incompetent, that rate that they brought, challenging the appointment of Madam Otiku Officer Jaba as Minister for Gender and Social Protection. Now, the court is holding that it is unable to hear the case because lawyer for the two plaintiffs, like I indicated earlier, Mr. Godwin Tamaklu, did not possess a valid Solicitor General's license at the time that the rate was issued. We've been speaking to getting a lot of reactions from Parliament as well. We've heard from the Vice Chairman of the Parliament's Legal Affairs Committee, Alexander Kujo, who is criticizing the decision by the Supreme Court to throw out that case. But then he sides with the Supreme Court when they criticize the use of Honourable as a precedent to the names of members of Parliament. The Supreme Court says that it is a constituency you're representing. It is not supposed to be a title. Well, what do the members of Parliament who went to court about Otiku feel? We'll be telling you in a bit. We'll be hearing from them in a bit. I'm going to hand over to Joseph Opoku-Gakpo now so he can have that conversation with the two members of parliament who took the case to court.
Okay. So very well then, I've been joined now by Ernest Nogbe. He's the Member of Parliament for the Ashaiman constituency himself, and the MP for the Jabosu area, Kwabna Menta Akando, filed that particular case in the Supreme Court, seeking to raise issues about Otiku Afisa-Jabber's approval as minister. Honourable, thanks very much for joining us. The case was thrown out earlier in the day. Let's begin with the fundamentals. Disappointed or otherwise?
Well, not really disappointed, and the case has not been thrown out. It has been struck out. We have, in legal terms, thrown out or strike out, and then dismissal are two different things. The case has been struck out due to some technicalities. So now we are going to, we'll go back to the drawing board and then bounce back. You know, when you look at the scenario, the judgment, today's judgment, you realize that I think the Attorney General was of the view that, or the defendant was of the view that there were some problems with our, lawyer, let me say so, to be precise.
Did you not do enough due diligence before getting him on your case?
Well, he did, because as at the time he filed for the case, he applied for renewal of his license. And according to the judges, as at that time, he did not have the license, the renewal of his license, though he has applied.
Did you bother to ask him to see his license before asking him to lead you to court?
Well, there was no way we were going to ask him. And if I can tell you for sure that we have a lot of lawyers who may also be engaged in this kind of activities, because we have procedural activities, we have administrative activities when it comes to renewal of licenses. You have to apply, and then it will take some time before the legal counsel or whoever is responsible will have to give you the license. But this man, or this our lawyer, has applied on the 9th of February, and he got the license on the 20th of February. So you realize that there was a little bit gap, and that is the technicality they used to strike out the case. But we have to come back. We are going to bounce back to see the end of this particular case, because it's not merely about Otiku Jabber, it's not merely about the president, it's not merely about the government, but rather the masses of Ghanaians who engage in national service and will not, at one point in time, not be engaged in public or private employment. So that is what we want to achieve.
Otiku has since been working. Something we've moved on, and probably it's an opportunity for you to let sleeping dogs lie. Will that happen?
We may let sleeping dogs lie, but at this point in time, we need to set some precedents, because this may not be the end of it. This may not be the first or the last. We may still have people who may not do national service, but will want to be employed in public service or even private service. So definitely we have to see the end of this particular case, so that we put this matter to rest, whether Otiku or not Otiku. Not necessarily, as I said, not necessarily about Otiku. What will we gain out of it? Not necessarily about Otiku, but what we need to do is whether if somebody does national service or not, is eligible to be employed in public or private organization.
My final question on this before I move on to the other bit. You made the point that there are a lot of lawyers who are in this same scenario, just as lawyer Eduji Tamaklo, who led you to court. Do you think the Supreme Court was unfair to you with their decision to strike out the case based on that, even as you are very much aware, you claim, that a lot of lawyers find themselves in similar situations and they are out there working on their case?
No, not necessarily. They did the right thing. I must be frank with you, they did the right thing by striking out the case because, one, our lawyer did not have the license at the time of filing. So it is genuine. We are not contesting the ruling. But what we need to do is to make sure that we see the finality of this case.
Why did you have to put the title Honourable alongside your names in the writ that was filed? Was it an attempt to probably intimidate the judges or anything like that?
Not necessarily. Actually, I think we contested an election, we won, and then when you come to Parliament, the moment you enter Parliament, you have become an honourable person. Now, if the judges, or especially the the Chief Justice is saying that we need not to attach that into. It's an advice, and we have to take it. And this one will go a long way to affect most of our colleagues who will want to be having a legal tussles with the Supreme Court or any other jurisdiction. That titles are not, they are not what we have to call. They are not necessarily to the Supreme Court rules. So you just mention your name, you just apply by your name, and then you go around. It is not only honorable. Doctors, professors, and so on and so forth. That does not have any legitimate distance on the Supreme Court.
The Chief Justice thinks, using that as part of your name is actually dishonorable. Do you feel hurt by such a description of your act, which, as you rightly indicated, was of good intention?
Well, no. Not necessarily, but that is his opinion. We have contested an election. We were voted for by people of our constituencies. The moment you enter parliament, you become an honorable person. And as a lawyer, you're also an honorable person. So definitely, whatever he says, that is his opinion. But we know our constituents call us honorable. And therefore, if we are applying for something, we have to indicate that. But if she is saying that, it doesn't matter whether you call yourself honorable or not, and we should desist from calling ourselves honorable when we come to the law court. I think that is her opinion, and we have to abide by that.
Will you continue doing that, at least beyond the Supreme Court, calling yourself honorable and holding yourself as such, and putting it out there on official documentation as such?
Normally, personally, I don't go by that. When you go,
but I did it this time around.
No, I didn't apply for this thing. It's my lawyer who did that. So definitely, you realize that it may not be your will, because when you go to my constituency, I ask everybody to call me Ernest Nogbe, because when you call me Ernest Nogbe, it brings me down to the level of the people. But if you call me honorable, you are creating a disparity. You are creating a very huge gap between me and the people, because the people will see you as somebody who is above them. They cannot approach you. So I always tell them to call me even Ernest Nogbe or Bra Ernest. That is the best thing. So, but in this case, our lawyer did that, and we cannot accuse the lawyer for doing that, because that is our title.
He appears to have done a lot of things that have got you into trouble with the Supreme Court this
time.
Is he staying on the case?
He's still on the case, and we have to still pursue that case. Yeah.
Many thanks for joining us here. And as Nogbe is actually the Member of Parliament for the Yashaman constituency, with those reactions there. Well, that position he just expressed, that, well, following the Supreme Court's directive, then they would desist from holding themselves out and getting the names out there as honorable. It's rightly the position that a lot of other MPs have been sharing, and they say they are taking a cue from the Chief Justice on this particular issue. Gifty.
Dakpo is our parliamentary correspondent there, bringing us up to speed. He's just been speaking to Mr. Nogbe, who took the case, of course. He likes to be called Bra Ernest. Well, let's hear what people have to say about this particular case. Let's go on Facebook now. Your comments have been coming in thick and fast. Let me start with Namaya Wampofo. He says, she just made my day. And by she, you mean the Chief Justice. Says, she just made my day. I've always held the view that the honorable title is for the House and not the members. I don't blame them, but the journalists who daily refer to them as honorable, as if it were a title. So you're basically blaming the journalists for this. Anthony Dublin says, send her to your privileges committee, because if someone else said it, you would have been so loud. In any case, she said that because you guys are NDC MPs. Anthony Dublin there. Kwesi Kafui said, when people or a sect of people from a camp that is full of their kinds, you will notice such lame, okay, I don't really understand, but you notice such lame things being done, and you say, chia, dishonorable so-called MPs. All right, so you don't, you obviously agree with the Chief Justice. Mamaga Della is asking you guys whether or not you understand whether you have read the content before you're putting in your comment. Nanaya Koro says, they're not even worth the title. LOL, you're laughing out loud, Nanaya. Patrick K. Redu says, definitely agree. So you definitely agree that the honorable title, if they use the honorable as a title, then they're being dishonorable. Joyce Mensa Ohime says, selfishness leads to dishonor. Okay. Natus Dako says, barbarians, Akando and Co. Oh, so, you know, let's work on the insults, right? Okay. Nadoka says, these people. So, well, these are some of the comments coming on Facebook. most of you seem to agree with the Chief Justice or with the Supreme Court that really the Honourable should be left for the House and not to be used as a title. Let's hear from people on the streets who've been speaking to us about this matter.
For me, what she said was okay, because for now, Ghanaians want to be known by their credentials. And without credentials, they see that there is nothing to be like uphold or they are nothing. So what the Chief Justice said was fine, because she needs to make this aware to Ghanaians so that Ghanaians will know that we don't only live in a country with credentials, because credentials are nothing. And with credentials, I think it's nothing, because what will you end if you die with it? You never go to heaven or you never go to hell with your credentials.
As I know about Honourable, is about someone who is so diligent, who is so respectful in the society or community, where he's being given the mandate to be their leader, and even the spokesperson for the community, and at the same time to the parliament. So it's like he's talking for the community, the mouthpiece for the community. So as for me, if I'm Honourable and if you just call me raw name like Ebia Aponsa, for that one, if you demean me,
I don't know if they educated to do the right thing, but if they know the right thing, then it's wrong to do that. So I think maybe she has a point. Ghanaians, we love titles down there. It's true.
We Africans and Ghanaians in particular, we are so much interested in titles. And if someone doesn't mention our title, we sometimes feel angry about it, which is not the best. If the title comes first before the name, it means you are so much interested in the title than the duty has been assigned to you, which is not the best. I agree with the Chief Justice perfectly, because I know with this one that the MPs are so much interested in the titles.
The Chief Justice is very right doing that. You don't know why you would go and use that sounding like it's yours, like it belongs to you, but then it was conferred to you on. It's not the right thing. So then it's right to mention the person's name first before the Honourable comes in. It's like when you go somewhere, I'm being practical over here, when you go somewhere and someone you don't know, they want to feel so big and like Honourable, yes, then like so that they have this position, like they get this kind of respect, and it's not the best.
If you are copying something from someone, you shouldn't copy blindly. You have to copy the right thing from whoever you are copying from. Some people are really obsessed with titles.
People are obsessed with titles. Are you or are you not? So basically, a lot of people seem to be on the side of the Chief Justice. What she's saying is that you are honourable member because you're representing a constituency and not, it is not a title. So it is not Honourable Gifty Andopia. It is Honourable Member of Parliament for so-and-so before your name comes. All right, you're still watching The Pulse with me, Gifty Andopia. It's been an interesting afternoon. I'm taking a very quick break here. When I return, I'm sure you want to hear from the former President Jerry John Rawlings. He's been speaking, and you know what happens when he speaks. Please stay with us.